recently the hearing was handed back to me. We've moved who's been the host. So while I am talking to you right now, I am activating the YouTube feed. I thought someone had done that, but if they hadn't, it's happening now. And I now see the YouTube screen. There's Mr. Forte on YouTube. He's now a television superstar. All right, they should, the folks you just mentioned, the alleged victims in the case, should be able to access the YouTube feed. My apologies that it didn't happen earlier. When I logged on, it let me straight in. It didn't. I didn't have to set up the YouTube thing. So they should be able to follow now. Back to you, Ms. Winfrey.
Thank you, Judge. The state's recommendation in this case is a 10-count indictment, and I'll go through each count as to what the state would recommend and any special conditions. Count 1, trafficking of persons for sexual servitude. The state would recommend 20 years to serve 16, the balance to be served on probation. Count 2, trafficking of persons for sexual servitude, 20 years to serve 16, the balance on probation to run concurrent with count 1. Count 3, aggravated assault, strangulation. The state would recommend 20 years to serve 5 years, balance on probation to run concurrent with count 1. Count 4, aggravated assault, 20 years to serve 5 years, the balance on probation to run concurrent with count 1. Count 5, terroristic threats, 5 years to serve concurrent with count 1. Count 6, false imprisonment, 10 years to serve 5 years with the balance on probation to run concurrent with count 1. Count 7, false imprisonment, 10 years to serve 5 years with the balance on probation to run concurrent with count 1. Count 8, pimping, 12 months to serve to run concurrent with count 1. Count 9, pimping, 12 months to serve to run concurrent with count 1. And count 10, keeping a place of prostitution, 12 months to serve to run concurrent with count 1. The state would also recommend that the defendant, Mr. Hamilton, have no contact, indirect or direct, with the victims in this case. And we suggest and recommend anger management classes for the defendant, that he cannot go to any establishments for any adult entertainment, and he is to stay away from 507 Bishop Street Northwest in Atlanta, which is Mark West Midtown apartment homes. If this case goes to trial, the state would not, we would ask for the defendant to have, if he's convicted after trial, we would not ask for concurrent sentences in this particular case. I will state for the record that the defendant's total exposure as to all counts is 105 years plus 36 months. That is his total exposure. And cumulatively, I guess the state would recommend basically 20 years to serve 16, the balance on probation.
Okay. Is Mr. Hamilton subject to recidivist punishment, Ms. Winfrey?
He is, Your Honor. We have filed a recidivist notice. He is a recidivist, and that notice has been filed with the court.
If he were to enter a plea today, would you be seeking recidivist treatment, or only if he were found guilty at trial?
Since he is subject to, since he's a recidivist, we would not withdraw that recidivist notice at this juncture, because the sentence can be probated as the court deems,
Sure. Okay. Got it. So, Mr. Hamilton, what I heard is that if you were to enter a plea today, the state would recommend what is effectively a sentence of 16 years in custody. Of course, you get credit for the time you've been in, followed by 4 years on probation. There were a series of conditions of probation, which we can work through if you were going forward with a plea. That's what the state would recommend. Ms. Patel would not be required to recommend that, but that would be the state's recommendation. Do you understand what the state would recommend?
Yes, sir.
All right, understanding what the state's recommendation would be if you entered a plea today, Mr. Hamilton, are you interested in going forward with a guilty plea, or would you prefer that I move your case onto our next available trial calendar?
Well, actually, Your Honor, I was under the assumption that my next court date was the 8th of September. So I hadn't been able to talk with my attorney again. This is a total surprise.
Okay, what made you think it was September 8th?
I'm sure that me and my lawyer discussed that. If the jail also pulled that court date.
Okay, well, Ms. Patel, is it your thought that giving Mr. Hamilton a little more time to speak with you about this would be beneficial? I don't mean today, we wouldn't do a breakout room, but if Ms. Winfrey is willing to keep the offer open until, he said September 8th, we can always reconvene. I do see in the docket that on the 21st, so 10 days ago, Ms. Winfrey filed the recommendation, and it matches what we just heard about. So I don't know when you and Mr. Hamilton were last able to speak. I'm not rushing anyone. Mr. Hamilton's not going anywhere. But we do need to work through the final plea, whether it's today or you let us know via email on or before September 8th if Mr. Hamilton wants to enter a plea or have his case put on a trial calendar.
So, Your Honor, originally, what I was going to ask today was to have Mr. Hamilton to see if we could reserve his final plea rights at least for a couple months. And the reason that I was asking this is that there is quite a lot of discovery that Ms. Winfrey has provided us. Much of that I've been able to copy and provide to Mr. Hamilton, so he does have an idea of the basis for most of the state's charges. However, there is a degree of electronic discovery that I would have to have my investigator go to the jail to show Mr. Hamilton, and the issue is that he's immunocompromised, and so I can't send him out to the jail until this part passes. In addition, Ms. Winfrey did kindly send me a copy of the paper discovery. She had served it to me. She had served a previous copy of the paper discovery before, but I was not able to provide a complete and total copy of that packet because by the time I made the copies for the client, I had to put it in a trial binder. And so I do want to get a total and complete copy of all of the paper discovery that Ms. Winfrey's provided to Mr. Hamilton. I'm trying to work with my office to see if there's someone else that could go to show him just the discs. And I am wanting to do this to make sure that if Mr. Hamilton decides not to pursue a final plea, that he does that knowing everything that the state has provided us with.
Sure, that's a fair request. How much time do you think we ought to extend this?
So it's not so much that we need another final plea date as just an opportunity for me to have someone go to the jail and talk to him. So if maybe we could I'm sorry, my internet gave out. If we could put this on for status in October to see if we can make any headway in that direction.
Okay, well, let me ask Ms. Winfrey. Ms. Winfrey, it doesn't sound like the state will need to be doing a whole lot of work on the case other than, of course, keeping the victims apprised of what's going on, but you've done great work getting all the discovery and getting it to the defense. Any reason you would be unwilling to keep this offer open until at least the status calendar that we might have in October?
No, Your Honor, that would be, we can keep the offer open, and I'm open to talking to Ms. Patel about the case at her leisure.
Okay, then why don't we do that? We don't need to repeat this discussion. Mr. Hamilton has acknowledged on the record, he understands how things change after the final plea date. After the final plea date, he is not free to withdraw a guilty plea solely because he's unhappy with the sentence he received. But I'm extending his right to do that at least through this status conference we have, and probably beyond that, because the status conference may just be the lawyers telling me, you know what, we have worked something out. And if they have, then when we can get Mr. Hamilton, even if it's a non-negotiated plea that they've worked out, Mr. Hamilton would continue to enjoy the right to withdraw his plea if he was unhappy with the outcome of the plea. So we'll keep that open. And for now, the state is agreeing to keep its offer of 20 to serve 16 on the table. And then Ms. Patel is going to work with Mr. Hamilton to get him more of the discovery in the 2 ways that she said she would. And we'll get a date from Ms. Nelson for a status update. Again, that may just be lawyers if we're simply saying we need more time or it just is not working out. And we'll take it from there with the goal of getting Mr. Hamilton's case on a trial calendar as soon as we start having trials if he has not worked the case out. Mr. Hamilton, does that work for you?
Yes, Your Honor.
Any questions?
No, not at this time.
So you're getting more time, you're getting more than just September 8th. Again, I don't know where that date came from. It's not anywhere in the docket, but that doesn't matter. You and Ms. Patel will have a chance to communicate more, and she may be able to find an investigator who can get out to the jail to share with you some of the video evidence in your case, and we'll take it from there. But so that we don't forget about the case, Ms. Nelson will get this on a status calendar for October. Ms. Patel, anything else in Mr. Hamilton's case?
No, Your Honor.
Ms. Winfrey?
Nothing further, Your Honor. Thank you.
All right, thank you for joining us.
Your Honor, that concludes my business with the court. May I be excused?
Ma'am.
Thank you.
This Ms. Jones?
Yeah, position number 7, Ms. Jones.
Hello, Ms. Jones.
Hi,
How are you?
all right,
Welcome back.
hi.
Ms.
Thank
Jones, I'm going to let Ms. Patel talk a little bit about what's going on, but I'm going to let you know that it sounds like the state is dismissing your case, which
Okay,
is a good development. But I'll let the state say that, and then you can let's listen to Ms. Patel first.
okay,
Thank you, Your Honor. Ms. Jones was an individual who was found incompetent, and then rather than being restored, we had her reevaluated at the jail because she was placed on medication and was doing well. And she has made quite the dramatic transformation from when I first met her. The complaining witness in this case is her sister, who all she wanted to do was to see Miss Jones get better. And she knew that it wasn't enough that for her to do it on her own. And so Miss Jones is doing well now, and the state is offering to dismiss the charges. Where we need guidance from the court a little bit is that we have a place set up for Miss Jones to be taken to. And so the goal was to have her released to accountability courts before the null process entered, so that Miss Jones is not immediately released to the street. I was not sure if a bond order has to be done with the order of release to make sure that nothing prevents Miss Jones from being transported by accountability courts to the.
So it's a good question. And if you were to ask the sheriff, or in particular the chief jailer, he would say, you better do a bond, because if you don't, the person remains in the sheriff's custody. So we have, unfortunately, dozens of defendants who are actually under DBHDD custody for all sorts of different charges, but because they didn't get a bond, they are legally still inmates, and the sheriff is arguably responsible for their whereabouts. So we would do a bond. What's the program to which Ms. Jones will be sent?
It's Viewpoint Mental Health, and Viewpoint is providing her with the housing, the address of which I do not have for the court yet.
Okay, and what's the drug court piece? They have graciously agreed to provide transport?
So, right, because the sheriff's office isn't transporting individuals right now, we have been relying heavily on accountability court to help us out with that. So I have spoken to a supervisor in our office, Ms. Markowitz. She said that we don't have a name for the person from accountability court just yet as to who would be taking her. So I would just ask that maybe the bond order just broadly say that she be released to someone from accountability court. And then once I prepare the order of release, that would have the specific information as to who would be taking Ms. Jones there.
And then when we got the green light showing that Ms. Jones had made it to Viewpoint and the housing that Viewpoint is providing, that would be sufficient for you, Ms. Hall, to move to dismiss the charges?
Yes, Your Honor.
Okay. Then my thought, Ms. Patel and Ms. Jones, I'll answer any questions you have about this in just a minute. My thought, Ms. Patel, is that you figure out the when and where of getting Ms. Jones transported to Viewpoint. And when that's been lined up, then I will do both the bond order and then I'll be signing the transport order that you'd be drafting that directs the sheriff to release Ms. Jones to the custody of accountability court personnel. And that's all we say. You don't have to say Fred Smith, just accountability court personnel, or transport to, and you fill in all those blanks. And I'll get those executed at the same time. So there's a bond and Ms. Jones is transported. Does that work?
Yes, Your Honor.
Okay. Ms. Jones, did you follow most of that? Do you have any questions about what we're discussing?
Yes, how long will it be before I'll be released?
That's a good question. The answer is real soon. Ms. Patel, your lawyer, is working with the folks who are finding you a place to stay. We just need to get those final details, and then I'll sign some papers that will get you transported to that place. So, Ms. Patel, are you thinking we're talking about a week or so, or what's a fair estimate for Ms. Jones?
I'm hoping we can do it by the end of this week. We're just waiting for Viewpoint to give us some very specific dates so that we can give that to accountability court to pick which one they prefer.
Okay, got it. So the goal, Ms. Jones, is to have you there by the end of this week. Worst case scenario to be early next week. So we're close to getting you to a good spot, okay?
Okay,
And you'll follow their rules and do what they ask you to do?
yes.
Great, okay. Well, thank you, Ms. Jones. Do you have any other questions?
No, my charges are dismissed, right? I won't have a record?
So I don't know if you already have a record, but these charges, once you get to where you're supposed to go, they will be dismissed. That's correct. Do you have other cases?
No.
Okay. Well, then you won't have a record because these charges will be dismissed.
Okay. Thank
Anything
you.
else?
No.
Okay. Well, good luck with things. You stay safe in the meantime, okay?
Okay, thank you.
Ms. Hall, anything else in Ms. Jones's case?
Nothing further from the state, Your Honor.
All right, well, thank you for your work on that. And Ms. Patel, we'll just look for the info from you, basically the transport order, because then that means you'll have gathered where and when and lined up accountability court, and then I'll take care of the bond.
Thank you, Judge.
Thanks, everyone.
Let me see here.
So I have down 2 people left.
We have Mr. Grogan,
Grogan.
Walter Grogan.
Got it, thank you. That's one of the 2.
Your
Hello,
Honor,
Mr. Grogan.
How you doing?
Okay, Ms. Hall?
I'm sorry, Your Honor. I was gonna ask if I can be dismissed. That was my last business.
Okay, so Ms. Hodge has 4, and she has, it's all, if Ms. Hodge is back, there she is, she's back, okay. Yes, do we see you this afternoon, Ms. Hall?
Yes, I'll see you at 2.
Sounds good, take care.
All right, thank you.
Mr. Grogan,
Yes, sir.
how you doing this morning?
Doing good, Your Honor. Yourself?
I'm doing okay. So we are going to talk a little bit about why you are in jail and what we ought to do about that. I'm just pulling your case up so that I can follow along with Ms. Patel and Ms. Hodge. So you have a pretty serious charge, but somehow you were out on bond, and now you're not. So we need to talk about what happened. I'm going to let Ms. Patel start, and then I'll also, of course, hear from Ms. Hodge.
Thank you, Your Honor. Mr. Grogan was released on a pretrial signature bond through pretrial services. And the warrant is for Mr. Grogan allegedly not reporting. I called pretrial supervision because I was slightly baffled as to why the warrant was issued, because I had been in constant touch with Mr. Grogan. He was one of the very few people that fell under this period of time where pretrial services didn't have the best track of individuals. He was released in March, I believe March 16th. And then he was transported to East Point for a hold. And that is around the time that everything had started to shut down because of COVID. Pretrial services stopped letting people come to the building to report. And so what they were doing is having their officers contact the clients instead to explain, individuals that were freshly released, explain how to report to them. And so when I spoke to the supervisor at pretrial services, they said that they had stopped doing outtake interviews because they had not developed a procedure method at the time when everything with COVID was just so new, that what they did is that they used the client's booking sheet to look at the phone numbers and addresses to reach the clients at. So I confirmed with the actual pretrial services officer to see what methods of communication she tried to use to get in touch with Mr. Grogan. And one of the numbers that she used to try to get in touch with Mr. Grogan was the number Mr. Grogan had before it was discontinued. So it was on his initial booking sheet, but it was never going to be a good phone number for him. The address with which they sent the notice to is not the address he provided the court the day of his, we filled out a change of address form and provided that to the court. We're by no means trying to put blame on pretrial services. This was a unique situation that they were in the sense that they could only use the information that they had, and they tried to make their best efforts. It just wasn't the information that Mr. Grogan would have given them as good information. I spoke to Mr. Grogan to see what efforts he had made when he had gotten released, and he said that he went to the building a couple of times and they were not letting individuals in, and they said your pretrial services officer will be in touch with you. I did confirm with pretrial that they were not letting people in at March because they had not figured out a good protocol with how to let people in. I do have his girlfriend on this call as well, because she can attest to the fact that they had called multiple times from her phone as well to see when he could report. She tried to get a copy of her phone records from her cell phone provider to show the number of times they had made an effort to call pretrial services, but they said that they would need a subpoena to do that. But ultimately, Mr. Grogan admittingly did stop making an effort sometime in April in terms of trying to get in touch with someone from pretrial services. And so we are asking that that previous bond be reinstated, and that he, this time, you know, I've spoken to pretrial services, their system is back to basically what it was. Clients are still going to be doing phone reporting and video reporting instead of in-person reporting, but at least they're back to doing the initial outtake interviews when people are released.
Okay, that was a lot of info. I'm going to play some info back to you all, and then of course I'll hear from Ms. Hodge. So Mr. Grogan, these allegations are from 2015. He was arrested in 2016. He got a bond in March of 2016, only on the rape count. It was the only count when he was arrested. It was a $15,000 bond by Judge Millender, and I assume it's just a good cash bond because it doesn't say signature bond. There's no pretrial services, just a $15,000 cash bond. You had to stay away from an address on Boulevard. That's March 2016, 4+ years ago. Then 3 years later, he's indicted. And that indictment adds a misdemeanor. He doesn't have a bond for the misdemeanor. But he also can't be found because maybe over the course of 3.5 years, he didn't keep everyone posted as to his address. He is eventually found, and in March of 2020, so this March, 4 years later, gave him a $1,000 bond on the misdemeanor, the family violence battery, through the sheriff's 10% program. And that has the pretrial supervision hook. So for several years, 2016 through 2020, he was not subject to pretrial supervision, at least as I see it in the docket, on a much more serious count. But he is as of March 9th of this year. There was a change of address form filed a few weeks before that lists a Fairburn Road apartment for Mr. Grogan. Is that his current good address, Ms. Patel?
I spoke to Mr. Grogan, I believe a couple weeks ago, and now have another address to give to the court that he says is better, and it's in Ellenwood, Georgia.
Okay. At the time, pretrial services was saying we can't find Mr. Grogan, or he's not reporting, or whatever prompted them to come off the supervision. Was the Fairburn Road address a good address for Mr. Grogan?
Yes, it was a good mailing address for Mr. Grogan.
But pretrial supervision, for whatever reason, did not have that address. They were operating off of one maybe from 2016.
Correct. They had an old address. It was 4900 Delano Way. And so that's where they had sent the notice to Mr. Grogan.
Okay. Even though in the system, before the bond that was entered that put him on pretrial, the new address had been entered. Okay. I think I'm following that. And then I guess a warrant issued in July because pretrial said we're done supervising Mr. Grogan, and he got picked up, and we are now working through that process.
Correct.
Okay, and your request, Ms. Patel, is we just have the two bonds back, the $15,000 good bond and the $1,000 through Sheriff's 10% program, pretrial supervision, and continue Mr. Grogan out on bond. Stay away from the alleged victim and this address on Boulevard.
Correct.
Okay. All right, Ms. Hodge, you've been listening quietly. Tell me what you think ought to happen here, and maybe you've got some additional info that I ought to hear.
I don't have any additional information, Your Honor. I understand the mix-up, but, and I'll leave it to the discretion of the court, but I would like to just have a follow-up with pretrial services within 30 days, so that if Your Honor does reinstate the bond, we can make sure that Mr. Grogan is on track and reporting.
I like that. I think that's a good idea, just to have them let us know all systems are go with whatever the address is. Okay, I think that makes sense. Mr. Grogan, you've been following all this?
Yes, sir.
You have any questions about any of it?
No, sir.
So Ms. Patel, you'll need to file another address update so that it's in the system, the change of address. You'll want to make sure that that gets to pretrial services as well. And Mr. Grogan, you're going to want to work with your lawyer, Ms. Patel, so that you've got phone numbers and email addresses for pretrial services. It needs to be easy for them to communicate with you, okay?
Yes, sir.
And this address out in Ellenwood, is that a okay place for you to be?
Yes, sir.
What's out there?
My cousin.
Okay. And does your cousin know you might get out in the next couple days?
Yes, sir.
Yes.
That's your cousin?
Excuse me?
Is Lisa Johnson your cousin?
Yes, sir.
Okay. Well, she says she's ready for you to come stay with her. Ms. Johnson, who else lives in the household?
My oldest kids. Just me and my children.
Okay. How old are they?
30, 29, 24.
Okay. And you know what Mr. Grogan's charged with?
Yes, I'm aware.
Okay. All right. Mr. Grogan, were you working before you got picked up?
Yes, sir.
What were you doing?
I was driving forklift for, I got nervous. I was driving forklift for the warehouse.
Okay. You think you can go back?
I hope I can.
Okay. All right. Well, that's what we're going to do. And then we'll just make sure that we get a 1-month checkup from pretrial to make sure everything is going okay. And we'll move on from there. I'm curious, Ms. Patel, is this a case that is ready to move forward? Where are you with discovery?
I don't believe there was a whole lot of discovery. The state gave me 3 recorded statements. I do have an update for Ms. Hodge that I'll provide her with because I have made contact with the complaining witness. It might be something that we can work out. It might just need a little bit more time for us to get to that point.
Okay. So you've been in touch with Ms. Banks. You're going to share that with Ms. Hodge. Ms. Hodge, any requests for bond conditions? What I've got, if I pull it back up, the bond I signed just said no contact with the victim. The standard, there were standard fare, and Judge Millender's order was to stay with no contact with Ms. Banks and then stay away from this address on Boulevard, which I assume back in 2016 was Ms. Banks's address.
Yes, Your Honor, no additional, just the original restrictions. Ms. Crawford did inform me that he also has an open probation case, so I would just like to remind him to make sure that his probation officer has his updated information because we will also be following up with him to make sure that he is reporting and complying.
Okay, great point. So Mr. Grogan, I don't know anything about your probated case, but you remain obligated to keep those folks posted as to your whereabouts. So this Ellenwood address you're going to need to share with probation, and that'll probably shift your supervision to, that's in DeKalb County. So you'll be supervised by probation out of DeKalb County. But again, the burden's on you they don't have to guess where you are. You need to tell them where you are. And they're not going to be up in your business too much, but they need to know that you are now a DeKalb resident instead of a Fulton resident, okay? So I will sign what I need to sign today. You may not get out today. It's now a little bit after noon. If you don't get out tomorrow, you should reach out to Ms. Patel, and then she'll let me know, and we'll figure out what the issue is, okay?
Thank you, sir.
And Ms. Johnson, Mr. Grogan is okay to stay there for the longer term, or is that a good place for him for just 1 week?
Ms. Johnson, you're on mute.
Yes, I'm here.
Yeah, is he able to stay with you for a while or just a minute?
As long as he promised to cook, he can stay as long as he can.
All right, good to know. Sounds like you're gonna be doing some cooking, Mr. Grogan. All right, well, thank you, everyone. We'll get the bond paperwork taken care of, and then Ms. Patel and Ms. Hives, keep Ms. Nelson posted if there's something we can do to move the case along. 19 SC doesn't seem too old, but when I saw the date of the allegations, 2015, the case is half a decade old. So I'm sure everyone would like some closure on that, if that's something you all can do. Thank you.
Thank you.
Mr. Kenneth White.
And that should be the last one for you guys.
Yes, sir.
Yes, Judge, if I could just very briefly speak to Mr. White. This is going to be a negotiated plea. I just wanted to go over it with him.
You bet. So I think this afternoon, one person is coming in. Okay. So I guess it's good that we have this fancy group.
I wasn't sure, and since I knew next week we're gonna be bringing everybody in, I just thought I'd go ahead and get it.
It's all good. I think we have an interpreter for the second. Both should be pretty short.
Just the pleas at 1:30 and the inquiry at 2 and 2:15.
The plea is off. That was going to be in person, the guy coming from Alabama. His lawyer is now unavailable, so the 1:30 is off.
Okay.
So it's just the inquiry count.
Yeah, you do.
Okay. You ready?
Yes, Judge.
Great, Judge.
I was asking Mr. Forte.
Oh, okay.
All right. This is position 2 on our jail calendar. It is, if this is printed correctly, 14 SC 127878, which is State versus Kenneth White. Are you Mr. White?
Yes, sir.
Mr. White, I'm Judge McBurney. I'm the judge to whom this case has been assigned. Your lawyer is Ms. Patel. You were just chatting with her, and the prosecutor for your case is Ms. Hodge. She's on the screen as well with the red glasses. Mr. White, before we can go forward, I need to ask you a few questions about the setting we're in. Normally, for defendants who are entering pleas, we have everyone in court where I'm sitting right now. In fact, you have a right to be in open court. Instead, you are in a courtroom in the jail. This is being broadcast, so it's public if you have friends or family members who want to be watching. And your lawyer is connected, but it's virtual. Do you waive your right to be present in court here today?
Yes, sir.
You also have the right to have Ms. Patel not just on a screen where she can see and hear you and vice versa, but to have her sitting right next to you. We cannot accommodate that in this setting, although we can, as you just experienced, let you speak to her privately in what we call a breakout room. Do you waive your right to have Ms. Patel by your side, and are you willing to proceed as we've designed it?
I'm willing to proceed.
Pardon me?
I'm willing to proceed.
Okay, then we're going to do that. Ms. Hodge is going to swear you in just a moment. Once you're under oath, everything you say needs to be truthful and complete. If you have any questions, please let me know so I can try to answer them, or so I can get you into that breakout room with Ms. Patel again to talk through whatever you need to talk through. Will you do that?
I understand.
Good, okay. And it's important when you are answering questions, because you got the mask and your remote, that you speak up. The court reporter who's here in court with me needs to be able to hear what everyone says so he can make an official record of what we're doing. Ms. Hodge?
Thank you, Your Honor. Can you hear me, Mr. White?
Yes, ma'am.
Okay, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand, thank you. Please state your true, correct, and legal name for the court.
Kenneth Latrell White.
And are you at this time under the influence of any alcohol, drugs, or medicine?
No, I didn't take my medication today. Yeah.
Is there medicine that you normally take that you have not been given today?
Yes. But
And
okay.
I'm sorry?
I say yes, but I'm all right.
Okay. Does not having that medicine affect your ability to understand what is going on today?
No.
Okay. How old are you and how far have you gone in school?
38, ninth grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the offense of failure to register as a sex offender or failure to comply with requirements?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer about this charge?
Yes, ma'am.
And do you need any more time to discuss your case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes.
Do you waive formal reading of the indictment?
Yes.
Do you waive any and all defects in the indictment?
Yes.
Okay. Has your attorney advised you of the minimum sentence, which is 1 year, and the maximum sentence, which is 30 years, for the charge you are pleading to today?
Yes.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend a sentence to the court, but the court does not have to accept that recommendation and can impose the maximum punishment allowed by law for this charge?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering a plea here today?
Yes.
And do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or special condition of probation without being subject to revocation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction can affect your immigration status and result in deportation, just as a conviction would following a trial?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of your plea here today?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea here today?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called against you, the right to assistance of counsel, the right to the presumption of innocence, the right to testify on your own behalf, the right to subpoena witnesses and compel the production of evidence, the right to have the charges proved beyond a reasonable doubt, and the right to appeal if convicted of this charge following a trial?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a plea here today?
No, ma'am.
Is it your decision to waive these rights and enter a plea because you are in fact guilty?
Yes.
And how do you plead to the charge of one count of failure to register as a sex offender in indictment number 14 SC 127878?
Guilty.
Is this guilty plea freely and voluntarily given with a full understanding of the charges?
Freely.
You understand you have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today to file a petition challenging the voluntariness of this plea?
Yes.
Your Honor, Mr. White was convicted in 2006 of a sexual assault crime on minors in Connecticut, in the state of Connecticut. In 2000, that sentence required him to register annually and update his registration as a sex offender. In 2014, he failed to report for his annual registration appointment, and a warrant was taken out subsequently. We are asking for a sentence of 1 year credit for the time that he has served, which is approximately 90 days, balance suspended. As I look at his criminal history, this is his first failure to register.
So it's 1 year to serve 90 days, balance suspended, or?
Yes.
I didn't follow how you structured the sentence.
Well, he had 1 year. He has served 90 days and the balance will be suspended.
Okay.
So I guess, well, let me correct that for the record. 1 year, served 90 days, commuted to time served, balance suspended.
Got it. That makes more sense. Okay. I think I follow all that. Let me ask Ms. Crawford about Mr. White's criminal history. I know there was something in Connecticut way back in '06, but I'll talk to Mr. White about that. Are there any Georgia convictions that are on your radar, Ms. Crawford?
Yes, Judge. He said he has active probation for 13 SC case. That case number is 13 SC 119793. It's for possession with intention to distribute cocaine and marijuana. And he has 2 years, 9 months, and 2 days remaining on that case.
Oh, okay. But that case is, it looks like a little older than this one.
Yes, this case is a 2013 case.
Got it. Anything else?
He has a case from 2010 is no longer active. Possession of a firearm by a convicted felon.
What county was that?
Both Fulton County.
Okay. So regardless of whether they're open or not, you've got 2 felony convictions. One is open, that's the drug case. One is closed, that's the gun case from 2010.
That's correct, Judge.
Okay. Got it. I'm just looking up that 13 SC case. Mr. White, okay, there he is. And there is a petition, so we may want to work through that today, but that's up to Mr. White and Ms. Patel.
And I did make Ms. Patel aware of that, Your Honor, so we are prepared to address that.
Great, okay. Is that part of your recommendation, Ms. Hodge? In other words, the revocation would not extend the 90 days?
Correct, Your Honor.
Okay.
And to continue on probation and make sure that he reports to probation, which is one of the reasons why we're suspending the balance of this current case, because we recognize that he will still have to continue to report on probation with the 13 SC case.
Got it. Okay. Ms. Patel.
Thank you, Your Honor. This case is from 2014, so it is pretty old. I informed Ms. Hodge that in doing my research, Mr. White has been in and out of custody for misdemeanor offenses in Connecticut since from 2011 all the way to 2016. The failure to register stems from failing to register in March of 2014. In April of 2014, I know that Mr. White was in custody in Connecticut, so I can't quite definitively say he was in custody at the time, but he has been extradited before from Georgia to Connecticut. I explained to him, even if the state takes you somewhere against your will, the moment you're released, you should have let Fulton County know, hey, I don't live there anymore. I'm stuck in Connecticut for, I don't know how long I'll be here. And so, you know, he ended up staying in Connecticut, I believe, until around 2016. I believe he was sentenced to stay in a halfway house. He recently has decided to try to come back to Atlanta. His mother lives here as well as his sister. That's how he was picked up on this warrant, was that he was driving with a friend. The friend's car, I believe, had either expired tag or something like that. They pulled it over. Turns out Mr. White had a warrant. I have been in touch with his family though. He believes his sister's address should be in compliance, and if it's not, they can put him up in a hotel off Fulton Industrial until he finds a more permanent place that's in compliance. But we are asking that Your Honor accept the plea as negotiated. I explained to him, now that he's back in Georgia, he does have to report as soon as he's released, and that he does have to report to probation because he is still on the hook for that 2013 case.
Got it. So Mr. White, are you originally from Connecticut?
Yes, sir.
But you now have some family down in the Atlanta area?
All my family is down here.
What's the Connecticut connection?
That's where I was born.
Okay.
That's where I was, but everybody moved down here.
Got it. So you grew up where in Connecticut?
Bridgeport.
And then folks came down to the Atlanta area, and you believe when you get out, you'd be able to stay with one of your relatives?
Yes, my sister, she would let me stay with her. I don't know. I never knew that she had got her phone number changed, and I was trying to contact her, but I know as well within 1,000 yards of everywhere. I mean, anywhere that's supposed to be stipulated on my like for the sex offender charge. But I know she'll let me stay there, and if
Okay.
not, my brother will pay for a hotel for me.
Okay, until you can find your own spot.
Yes, and I do have a job waiting on me when I was working down here for ASI. I was working for the Georgia World Congress Center and
What do you
the
do
GICC Congress Center and stuff like that. Like a
there? Right.
temp.
Well, I know what the World Congress Center is. It's not doing a lot of things these days because we're not having a lot of conventions. What kind of work did you do there?
They call it like housekeep. They call it housekeeping, but like taking out the trash and doing other stuff, like for the
Okay.
shows and stuff like that.
All right. But you've had jobs in the Atlanta area before.
Yes.
Okay. All right. And what's behind all this is something that happened back in '06 in Connecticut. Is that right?
Yes. A female lied to me about her age in the club, and when I found out her real age, she got upset and told her family that me and her was intimate with each other. Her
Did
mother
you go
just
to
got out
prison?
of jail, so she just told her mother that.
Okay. Did you go to prison for that?
Yes, I did 2.5 years, and they extradited me for that pistol charge in 2013, and that's when I caught my second felony down there. I mean, I did another year and a half down
Okay. Do you have kids?
there. No, sir.
You mentioned that you normally take medication, but you did not take it today. What do you take medication for?
Depression and voices.
Okay. You told Ms. Hodge that the fact that you did not get your medication today is okay in the sense that it's not affecting your ability to understand what we're talking about. Is that true?
Yes, it's not because I took my medication early this morning. I mean, like around 2 o'clock this morning, she brought me some more medication.
Okay, so for right now, you feel stable and like you're able to understand what we're talking about.
Yes, sir.
Okay. Anything you want to add, Mr. White?
No, sir.
Well, I find there's a factual basis for your plea. You knew you were supposed to register and you didn't. It may have been in part because you were stuck up in Connecticut for something else that happened up there. But there is a basis for the state to prove that you did not register when you were supposed to here in Georgia. You know how to do it, and it sounds like you're gonna be staying in Georgia. So Ms. Patel is correct. When you get out, and you'll be getting out shortly, other than hugging the family and whatnot, you better go register so that this doesn't happen again.
Yes, that's gonna be the first thing I do.
Pardon me?
First thing I do when I get out.
Okay. Will you be living in Fulton County or a different county?
Fulton.
Okay, so you know where to go. It's actually in the building I'm in right now.
Yes, I do.
Take care of that. And you'll need to plug back in with probation as well. You remain on probation in that the drug case, the 13 SC case. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we talked about. Is that a true statement?
Yes.
And voluntary simply means no one's forcing you to enter this plea, but that you've decided it's the right way for you to move forward. Is that also correct?
Yes, sir.
Then I'm going to accept your plea. I will follow the recommendation of the lawyers and sentence you in this case to 1 year to serve 90 days, and I will suspend the balance. So you will not have any probation on these charges, but you should know that, and I'm making this up, but we'll pretend a month from now, if you were to do something that got you in trouble, the state could petition to revoke your suspended balance, which would be like 7 more months or something. So it's not a lot of time, but the fact that it's suspended doesn't mean that you don't have to worry about it at all. It just means you're not on probation. Of course, when you get a year out, you don't have to worry about it at all, because then the sentence is all over, even the suspended part. Ms. Patel, I'm prepared to handle the revocation of the 13 SC case as well. Sort of, you have notice of it because there's a petition out there, but you really don't have notice that we're going to deal with it today in court. Does Mr. White waive his due process notice right?
Yes, Your Honor.
And your recommendation is that whatever I suspend be concurrent with the custodial portion of the sentence in the 14 SC case?
Yes, Your Honor.
Ms. Hodge, you agree with that?
Yes, Your Honor.
Okay. Then, Mr. White, in the case of 13 SC 119793, I find that you have violated your probation in that case because you have a new conviction. It doesn't feel real new to you because it's a case from 2014, but that case is newer than the 13 SC case, and your conviction is brand new. It's as of 2020. And that's a violation of your probation in the 13 SC case. I will revoke 2 months of your probation in that case, but I'll give you credit for time served, and I'll reinstate the balance. So you're going to have 2 years and 7 months thereabouts of probation remaining on the 13 SC case. Does that make sense?
Yes.
Any questions about any of that?
No, sir.
Okay, so when you get out, register, let probation know whatever address you're going to be staying at, and then go about your business. Ms. Patel, anything else for Mr. White?
No, Your Honor.
Ms. Hodge?
No, Your Honor.
Okay, I think that's it. Thank you.
Thank you.
Thank you, Your Honor.
Have a good day.
You too.
Judge, I have one question.
Ms. Crawford?
I just wanted to know, what was the credit from date?
Good question. Let's look. Just stay there for 1 minute, Mr. White. And do you need to talk to Mr. White about reporting?
Is it June 10th, 2020, Your Honor?
I'm looking.
Okay.
So on June 4th, I signed an order. We'll say June 4th. That's when I lifted the judicial hold. So Mr. White must have been in custody here by June 4th. And so June, July, August. So that credit from June 4th. That way the probation piece isn't keeping.
I came here to Fort. I was in Decatur, but I came here on the 3rd. They extradited me from Decatur. I was in Decatur's jail June the 1st.
Why were you there?
For this warrant.
Okay, they just took you to DeKalb first?
The person's car that I was in, they was for homicide.
Well, that's quite a car to be in.
That I was excluded out of that because I was going to see a female, and I had that all on my phone. That me and her was talking on Instagram of me coming to see her, and I told her that I had found a ride, and I had paid him $20 so he can get gas just for me to go get her. And that's when the police, but I had nothing to do with that because they brought me back over here, and they just told me thanks for my cooperation.
Okay. Well, we're going to say June 4th. That's not going to change anything for you. Ms. Crawford, do you need an address for Mr. White?
Yes, Judge, that's correct.
Mr. White, where are you going to be staying when you get out?
2224 Abner Place, Abner, Atlanta, Georgia. And I don't know the zip code 30318 or 14. It's one of them.
Do you have a telephone number and an emergency contact person's name and number?
My mother is my mother, but I guess my sister has a changed phone number, but I can get that when I get out. I only have a Facebook. But my mother's number is 678-760-5226.
What's your mother's first name?
Darlene,
Last name, same last name?
yes, ma'am, White.
Okay, Mr. Wright, I'm gonna give you 48 hours after your release date. You would need to report to 276 Memorial Drive Southwest. So if you get out, you're gonna have to report on a Wednesday for registration, for your sex offender registration. So if you get out Monday or Tuesday, or if it's after Wednesday, that following Wednesday, I need you to report at 10 a.m. And it's 276
Address?
276
Mm-hmm.
Memorial Drive Southwest,
Okay,
Atlanta, Georgia, 30303.
okay.
Report on a Wednesday morning at 10 a.m.
Wednesday morning, 10 a.m.
10 a.m. Yes, sir. And I'm gonna give you my work number, okay? If you have any questions, you can reach out to me.
Okay.
Okay, it's 470
Mm-hmm.
303 6860. Miss Crawford.
I got you.
That's it for me, Judge.
Okay.
Thank you. You have any questions?
No, ma'am.
All right, well, I think that's it. Thank you, everyone. Thank you, JL, for getting us everyone.
Thank you.
All right.
Thank you, Your Honor.